Hello, my name is Garrett. I'm a solicitor in the family team here at Hay & Kilner, and I'm going to be talking about the divorce process in England and Wales. Divorce is the legal process that formally ends a marriage. In England and Wales, you have to have been married for at least 1 year before you can apply for divorce. Since 2022, we have had what is known as a no-fault divorce system, which means you don't have to blame your spouse for the reason that the marriage is ending. You just have to prove that the marriage has irretrievably broken down. You can apply for divorce either by a paper application and send that off to the court, or you can now do it online, which is a lot more of a simpler process and is a lot more efficient. This can be done as a sole application, or it can be done as a joint application as well. There is a court fee of £612, but if you are on a low income or you have certain benefits, you may be entitled to help with your fees. When you apply, you have to provide personal information such as both parties' full names, the addresses, your solicitor's details if either parties are represented, and you do also have to provide your original marriage certificate and evidence of any name change if that does apply to you. Once the application is made, the court issues it, which is known as the date of issue, and this is when the process formally starts. The other spouse, known as the respondent, then receives what's known as an acknowledgement of service, which asks them to confirm that they've had safe receipt of the divorce application, and they need to state if they want to accept the divorce or if they do intend to dispute the divorce. The document should be returned within 14 days. The respondent can now only dispute a divorce in very limited circumstances. So for example, if the court doesn't have jurisdiction, if the marriage wasn't legally valid to begin with, or if the marriage has already ended. There's then a minimum waiting period of 20 weeks from the date of issue before the applicant can apply for the conditional order. This is designed to give both parties some time to reflect and hopefully allow both parties to reach an agreement with finances and with children as well. Once the conditional order is granted by the court, this confirms that the court sees no reason why the divorce cannot progress to final order. And then after 6 weeks and 1 day, the applicant can then apply to the court for the final order, which is the document that legally ends the marriage. If the applicant does not apply within 3 months, then the respondent can then apply for the final order. In practice, the whole process generally takes around 6 to 8 months, just depending on how quickly each stage is progressed. I think the main thing that people need to be aware of is that the divorce is only bringing an end to the marriage itself, and it does not automatically deal with financial matters such as property, savings, any pensions, until you receive a final order from the court, either made by agreement or directly through the court. Then you will remain financially tied to your spouse and you will still have financial claims against each other. So that's why it's so important to address the finances alongside the divorce as well. So we can guide you through every stage of the divorce process. We can make the initial application on your behalf and deal with the necessary steps right through to the final order. We can also advise and represent you in relation to financial matters to make sure your future is protected, and also help you resolve arrangements for children in a way that works best for you and your family. Our role is to give you clear advice, take away as much of the stress as possible, and support you from start to finish.